to be involved in. I feel really fortunate. Trademarks are just one aspect of intellectual property, but one I'm like particularly passionate about. By the end of this session, hopefully you feel a little bit that way too, and at least be energised to implement them in your business. So does everyone recognise this famous logo, even though it's mostly covered out? Yeah. Barbie logo. Why do you know this? Because it's brand recognition. So imagine a world where products lack this sort of distinctive mark or logo, or everything's just in plain packaging, nothing to indicate their source. How do you know the difference between like a genuine Barbie doll and a knockoff? This is the power of trademarks and why they're such a valuable business. As I said earlier, trademarks are just one of a variety of intellectual property rights. So I'll give a quick rundown of some of the others. There's copyright, and that protects creative content such as music, photographs, drawings, and books. Patents, which protects inventions. Designs, which can protect the overall visual appearance of a product. And there's also confidential information and trade secrets under the intellectual property heading, and some specific regimes for plant breeders' rights and circuit labels. We don't hear that much about. Today's session is largely focused on the intellectual property right, which is trademarks. So first, I'll outline what a trademark is. Then I'll look at some tips for creating a good trademark, why availability searches are important, and the benefits of trademark registration and risks if not registered. I'll also explain the interaction of trademarks with business names and domain names, and look at common intellectual property structures and how to avoid some of the risks associated with these. Finally, looking very, very briefly at another IP right, which is copyright, I'll describe some issues you might find similar to the brand. Trademarks are important assets of a business. They're used by every business all the time. This is different to things like patents and copyright, because they might only arise in some businesses depending on the nature of your business. So whether you've got inventions and whether you've got literary works, but every business uses trademarks. Trademarks enable the customer to identify the brand of the business and to differentiate that brand from others in the market. This can be extremely valuable. Some of the obvious valuable ones are Apple and Google. Their brands alone, let alone their profit generally, their brands alone are valued in the hundreds of billions of dollars. So what is a trademark? As defined in the legislation, it's a sign or symbol that is used to distinguish the goods or services of one trader from another. So your business name, your brand, is often your first trademark. This is your overall trading name. Sometimes it's called a house mark. Often it's just the name of the company, such as Apple or McDonald's. Trademarks also extends to images. So the next most common trademark you'll see is the logo for business. Then lots of businesses also develop and use other trademarks in the course of their business. Most often this is a product mark, which is just basically the name of your product. And this might be things like the iPhone or the big. A slogan or a tagline can also be a trademark, as long as it's used to distinguish your goods or services. What springs to mind when you hear, oh, what a feeling? Toyota's protected that by registration of a trademark. So no one else can use that in relation to the similar services. And McDonald's slogan, I'm loving it, is also protected, trademark registration. We've also got some more obscure types of trademarks. There's ones for sound, colour and scent. These can be used as a trademark, although they're not particularly common. We don't see them that much. One example you might know is Cadbury's colour purple, but it's chocolate, so that's a registered trademark. No one else can use that colour in relation to chocolate. Although many of you might already have an established business name, you might still be continually developing products or marketing new brands. So there's some things you can think about to ensure you create a good trademark. Although there's an obvious temptation to use a word that's suggestive of the product or service that you want to sell, In order to be capable of registration, a trademark actually has to be the opposite. It needs to be distinctive and not obviously related to the goods or services to which it's to be used. To put this another way, must distinguish your product or services from those of your competitors, and it cannot describe your product and services. Some examples of marks which were found to be not sufficiently distinguishing by the Trademark Office are mobile skips in relation to waste collection and disposal. So just mobile skips just indicates a mobile waste collection mechanism. It seems a little bit hard, but that was seen to be not sufficiently distinguishing. Snow theft is a bit more obvious. Snow theft in relation to entertainment services, included ice sculpting and ice skating, so that wasn't allowed. And flexi roof in relation to sale of roofing materials or other building materials was also rejected. So what you need to do is have a made up or unique word as your trademark. Many now famous brands used invented words which have now become synonymous with their business. Think about things like Rolex, Kodak, or Spotify, just entirely made up words. Not going to be accused of being descriptive. Another way to have a good trademark is to use a common word which is entirely unrelated to your product, such as Apple in relation to electronics or Virgin in relation to the airline. So in that way you can create a distinctive trademark in relation to goods or services that are different to the name you're using. Whereas if you used Apple in relation to a fruit store, then that wouldn't be distinguished. Trademarks which include a graphic element such as a logo or the overall packaging that can assist to create distinctiveness, even if you've got your descriptive words contained in the logo in some cases. However, it's not a fail-safe. If the words are still the main distinctive part of the trademark and they're descriptive, then you probably won't overcome problems with lack of distinctiveness. So not only will a descriptive trademark be at risk of rejection for registration by IP Australia, there's also a danger that others will wish to use the same sort of description in their business. And where you've got close variations to your trademark used in a describing way, then they're more likely to be able to be used by others without infringing. Despite all of this, it is possible for a mark which is not inherently adapted to distinguish to become distinctive through use. So this is how some even seemingly relatively poor trademarks on the face of it, if they have a substantial capital backing and they're used a lot and made well known, then they can be registered later on. And then they can enjoy a monopoly and restrict other traders from using those terms. A good example of this is Apple's registration of App Store. So in 2008, Apple made an original application for App Store and that was rejected. I'm presuming this is based on the fact that it lacked capacity to distinguish because it was just describing a place to buy apps for a smartphone. However, by 2018, it obtained trademark registration of App Store. And this was in relation to an online retail store for computer software for use on handheld electronic devices. And it got this by filing evidence of use, indicating that App Store had become known and associated with Apple. So I'm going on about how it has to be unique, distinguishing. You might be thinking, what about this brand over here? So if it's a big brand and they've got substantial capital backing and they've used it a lot, then they can claim that it's become distinguishing and they'll still get registration. When it comes to practicalities of registering a trademark, one of the most perplexing issues is the need to nominate the class or classes that you're going to have for trademark. In Australia, there's 45 classes of goods and services for which trademarks can be registered. Then within each class, there's hundreds of services and good descriptions that you need to specify that are all listed there, or you can create your own as well. So it's important to take care with this selection and make sure you cover all the goods and services that you're going to use the trademark for in your business. But it's also important to not include things that you won't use it for. as I said, sometimes you look at the list and your product's not actually there, and it's possible to write your own description, but you still have to get this in the right class. So you have to know what all the classes stand for. It can get tricky. One of my clients has a spraying grass product, and that's not specifically listed in the class descriptions. He was actually going to come today, but he's sick. He might have got a pick of that. So a spraying grass mixture contains grass seeds, fertilizer and mulch, and some other things as well. But they're the main ingredients. And as a chemical, fertilizers are covered by class 1, but mulch needs to be covered in class 31, and so do the grass seeds. So you end up with more than one class just to cover your single product. And that's quite a unique example. Lots of people can get away with one class, but you might find that you need more than one to cover what you think is a pretty narrow business. Rental business is another one. We have a rental business client, and if you're renting a lot of different things, you have to put it in a lot of different classes.
So it's different costs.
Yeah. So the if you can pick off the list, then it's $250 for the IP Australia fees, but if you have to write your own, it's $400 per class as well. Yeah. If you've got one class from a peers, you can get quite a cheap trademark. But if you've got 3 or 4 and you have to go out them yourself, then it's into the thousands. So the reason that the selection of class and the selection of your goods and services specification within that class is so important is that your trademark is only going to be able to be enforced for the goods or services for which it's registered. That is, if you want to make an infringement claim, this is only going to be able to be made against a sufficiently similar trademark if that trademark is being used in relation to the goods or services that you've covered in your application, or goods and services which are closely related to or the same description as those covered by your trademark. So you need to get this right. There's a bit of a temptation to apply for like a lot of goods and services in your class because it's payment per class, so people want to feel like they're getting value for money, so they just try and pick everything. But if you pick things and then you don't use your trademark for those goods and services, that can lead to removal for non-use. And I'll talk about that later, at least for the goods and services that you're not using it for. Sorry. Some prohibitions and restrictions, just a few to be aware of. A trademark will be rejected if it's scandalous or contrary to law. So scandalous marks are those which might have like an element of personal abuse or racial or ethnic abuse. If it's religious intolerance or religious abuse, they're all going to be considered scandalous and rejected. It does need to be more than just poor taste, like swearing is now acceptable, but I don't know, perhaps when the trademark register first came out, that might have been something that was scandalous, but as community changes, what will be scandalous could change as well. So but if swearing's directed at a person, like a politician, I think was some of the examples they give, then they'd be rejected. There's only a few examples of what might be scandalous or what has been refused as being scandalous, and mostly they're not appropriate to repeat. There is one case in America, so though in Australia, it's a similar sort of as an example. The word Redskins was cancelled, like their registrations actually got cancelled, even though that Washington Redskins American football team had been using it for such a long time. And that was because it was disparaging or offensive to Native Americans. And I think another Australian example is, and I don't know about the trademark situation, but the Coon to Cheer. I don't think that they were challenged at all and they changed it of their own volition, but that might have been something that was open to challenge anyway down the track. So.
Insinuating words like lunch, so saying the actual word.
Yeah, well, I think they will let the word in.
Yeah. Insinuates different word.
And there's the clothing brand, the FCUK.
Yeah.
Clothing.
FCUK, yeah.
The most common issue that's raised as being within the contrary to law prohibition is if the trademark's likely to deceive or cause confusion or otherwise breach the Australian consumer law by a misrepresentation of some kind. One example is a trademark if you use a famous person's name or image to connote a connection between the goods and services when there isn't a connection. That might be contrary to law as misrepresentation. Also using a geographical indication, which winery people would know about, on a product when it doesn't come from the location that's represented by that geographical area. That could also be a misrepresentation and thereby a ground for invoking misrejection. There's also some specific prohibited signs to consider. It's probably just best to check at the time, but things like flags of various countries, the Geneva Cross, other official signs and emblems will be prohibited. Still, some more tips. You need to use your trademark. Trademarks need to be continually used in order to maintain their registration status. If a trademark's not used for a period of about 3 years, another party can make an application for removal of the trademark for non-use. So you might be thinking like, of course, I use my trademark, it's my business name, I use it all the time, it's not a big deal. But what you need to be careful about is ensuring that you use the trademark in the form it's registered. So if you've registered 3 ducks on a pond wine as your trademark, then you have to consistently use all of these words to promote your business all the time without shortening it to say 3 ducks wine. That's going to diminish the value of your trademark. You won't have as much use. Similarly, if you've registered a logo and you refresh the brand and update the logo, if it's sufficiently dissimilar that it's not going to be an infringement, then the old logo is essentially going to be open to use for other people. Also in this scenario, when you do have a new brand, you need to do a new trademark application because you can't just update your registration, and that can affect your priority date as well. And that's why it's also good to, if you can and they're not descriptive, get the words of your business as a trademark registration. Another situation can arise where the words of a business, so even if you get the words of your business name registered as a trademark, but then you exclusively promote your business with a logo that doesn't contain those words, then you won't be using your trademark as registered. So that might happen in an online business, for example. So you've just got your logo on your website, social media pages, and there's not much else going on. And then your trademark would be at risk of non-use. The next one, some of you might know this one, that there can be no conflict with existing trademarks. So IP Australia will initially reject or at least query your application if there's an existing trademark which is what we call substantially identical or deceptively similar to a trademark that's already on the register. So substantially identical and deceptively similar are terms that have been widely discussed and interpreted by the courts, and so there's precedent cases around the meaning of these words. So deceptively similar will be where the impression of the imperfect recollection of a consumer, which is carried away and retained, might lead to a mistaken belief that the trademarks are from the same source. So that's like if a consumer's in a shop and they see 2 products on a shelf, if they go away and might be confused that they're the same product, then they could be deceptively similar. It's what they've remembered after they've left. To determine whether a trademark is substantially identical, it's more of a side-by-side comparison. And you look at all the visual aspects, and they will also look at the oral aspects about how the trademarks are spoken. You know, when they put like the number 2 in the middle of a trademark and things like that. So they'll think about how it would be said and whether in that comparison right next to each other, if they're similar, then they'll be substantially identical. And I just thought I'd go through some examples to test for you. So and these are all real cases. So there was barefoot, the word was registered, and someone came up with a barefoot Radler logo to put on their alcoholic beverage. One was beer and one was wine, and they have actually also found that they were similar enough services, and then had to determine whether these were substantially identical or deceptively similar. Does anyone want to have a guess?
I've seen both brands and I've been confused as to whether they were one and the same.
So you'd say they're
I'd say
at least deceptively similar.
yes.
That's what the court said. They're not substantially identical, but they are deceptively similar. And then we've got the clinical imaging people, both using insight and green and a circle.
Substantially identical.
That's what caused it. Yeah. I thought it was surprising too. But it's also because radiology is descriptive. So, and so is clinical imaging, so they're not descriptive. Yeah, the circle's similar, insight's similar, and you could take off radiology and clinical imaging because they're descriptive and they look very much the same. So this is what their honors said, so it has to be right there. And then we've got Wicked. This is all about a Wicked sister make desserts, and the Wicked brand was about chocolate dipping sauces. So again, a little bit tricky to find them similar, but they did find the goods similar. And then it was whether, I think that's right actually. Then it was whether Wicked was the same as Wicked sister.
The W's. Right.
Oh, because they've both got the little.
Yeah.
Combination.
None of them are risque bands.
Pardon?
None of them are risque bands.
So they're not substantially identical and not really similar. Maybe for the last one. But sister is, it's not, it's one of those words that's being used in relation to different goods or services what sister means. So it's nothing to do with desserts. If it was Wicked desserts versus Wicked, that might have had a bit more trouble. And so coming back to my first tip, create a distinctive trademark. If you've got a unique trademark, like a word that you've made up, then you're far less likely to come across clashes like this, and your trademark could be substantially identical or deceptively similar to existing mark in the first place. Now, in order to identify any potential conflicts with trademarks that might be substantially identical or deceptively similar, you need to do availability searches. And these are best done before you choose your business name or before you do new branding. Thorough searching involves searching the Australian trademark register and any international registers if you're exporting, and also national and, if relevant, international common law searches, like through the internet and social media pages. And these searches can identify any similar words or images being used as trademarks within the scope of the goods or services applicable to your industry. And as you've seen, it's not just a matter of searching for something that's identical. It requires consideration of similar terms, phonetic and oral similarities. And as you saw in the examples, it's not always going to be a simple task. So you need a good knowledge of the current legal position and its application. And you always say to get them done by an expert. Search results will show not only if there are impediments to registration of the trademarks, but also if there's a risk of infringement for another trademark that's maybe not registered, or if there's a risk of claim of misrepresentation or that you're being misleading or deceptive with another brand that's out in the market. So if infringement is alleged against you later on, the fact that searches haven't been undertaken can reduce your available defences, such as the ability to rely on faith. And searches are also useful to identify which trademark owner is the first user if this becomes necessary down the track. So, I mean, searches can be a further upfront cost, especially if you get an expert to do it, But it's really worth it to ascertain if a brand can be used without infringing another person's trademark before it's launched into the market. Indeed, even if you're not considering registration, searches are still useful because you don't want to go to all the trouble of building building value in a brand or a trademark only to find that your trademark then infringes someone else's later. Searches can also be utilised to keep an eye on your competitors. So once you've got your registration, to ensure you're getting the benefit of your trademark protection, you need to be on the lookout for risk of trademark infringement and counterfeiting. It's a good idea to maintain regular searches of the trademark registers and business and company name registers going forward, as well as internet and other searches, and that can ascertain whether there's potential infringement of your trademark occurring. And sometimes it's deliberate, sometimes it's an accident, but if you keep an eye on everything, you can see what the other trade is up to. Take the care to maintain your trademark. You'll be in a better position to consider your options for taking action against the infringer. You can't guard against what you don't know about. So while there's not a requirement to register trademarks, there are a lot of benefits to obtaining a trademark registration. The main thing that registration of your trademark gives you is exclusive rights to use your trademark in Australia. And as part of that, it gives you access to specific remedies for infringement against signs which other people use in relation to similar goods or services if they're substantially identical or deceptively similar to your trademark. So without registration, if you have an unregistered trademark, then you need to rely on actions for passing off misleading, deceptive conduct or a misrepresentation of an association or affiliation with the business. So
Can you repeat that and expand on it?
I'm going to expand on it. Yeah. So if you don't have a registered trademark,
Yes.
you still have some rights, but the actions you have to rely on are called passing off, which is a common law action, misleading, deceptive conduct, and misrepresentation of an association or affiliation with another business.
Right, okay.
So all of those require proof of reputation in the marketplace. Maybe I'll just expand now. So passing off is a common law action as aimed at protecting goodwill and reputation of a trader in circumstances where another trader makes a misrepresentation damaging the goodwill and reputation. So it's all about trading off the reputation of another business, and therefore, you need to prove reputation. That's quite crucial. It also requires proof of damage suffered, and that's not required for a claim of trademark infringement. So sometimes you might not have suffered a damage or a loss because it's just a new person starting up, or they've just done something small on social media, or they're a not-for-profit, but you still want them to stop using your trademark, and a passing up action isn't going to work if you haven't suffered damage, whereas you can make a claim for trademark infringement if you've got a registered trademark. Misleading or deceptive conduct or misrepresentation of an association or affiliation, they're statutory actions under the Australian consumer law. So the aim of those laws is really to protect consumers from this type of conduct, but they can be utilised by other businesses. Still, the focus when you're making these actions still remains on the effect on the consumer and whether they've been misled or deceived by the similar business name or other trademark. So you need to have proof of reputation for both of those claims. So sometimes if you're a small business or a startup, you haven't acquired a reputation yet. Difficult. And overall, having a registered trademark is going to put you in that strong position than attempting to make out one of these claims for an unregistered trademark. Once registered, you don't need to prove reputation, you don't need to prove deceit or confusion of consumers, and you don't need to show damages. The focus is just on the registered trademark and whether the other trader has a substantially identical or deceptively similar trademark. So say you conduct a cleaning business through a company and it's called Superior Cleaning Care Proprietary Limited. You use this name, it's your company name, you use it to promote your business and supply cleaning services. We'll be really happy to discover that another business is also providing cleaning services down the road from you and using the name Superior Cleaning and Care, just an and. You feel like they're infringing your brand, Superior Cleaning Care, and using your trademark to get an advantage. Particularly if you put a lot of money into advertising or promotion of your brand and think you're fairly well known in the market. But without a registered trademark for your Superior Cleaning Care, even though it's your company name, without a registered trademark, you won't have a claim for trademark infringement. You therefore end up relying on the common law claim of passing off or misleading or deceptive conduct or a misrepresentation. So it's probably not difficult to demonstrate confusion of consumers in a case like this, where the only difference in the name is and. You still need to demonstrate this reputation in the marketplace in the name Superior Cleaning Care. There's a little bit of an extra difficult element because it's a little bit descriptive.
So it was Three Little Pigs, if you were in Three Little Pigs stories, yeah, the story is that copyright or trademark. If you're using that off as a business, for instance, you're taking that name from
From an existing business.
yeah, from the existing story,
Yes.
from the existing. That's
So he's
Maybe
using
true,
it as a trademark.
yeah, or yeah,
Like his-
yeah,
like his butcher sign, I guess,
yeah.
He's using it as a trademark for his butcher.
Yeah,
Yeah, so if someone down the road is Three Pigs,
Yeah.
then that's trademark.
okay.
If you've got a trademark, and if you don't, then you have to sue for passing off or misleading and
It's
deceptive.
not relative to story or.
Not sure about that.
So should you get the name from something and how to apply it if you
Oh.
trademarking signal, so.
Doesn't really matter why he shows it, is that what you
Okay.
mean? The story.
Where you got it from?
Well, yeah, if you've made up yourself, if you've copied it from somewhere, then it's copyright
That's
issues.
yeah,
Yeah.
I'm thinking.
Yeah.
But does it
There's a
change
logo
because
there.
one becomes a story and one becomes a business of food?
Oh, I see, you mean the actual book, yeah,
Yeah.
I'm with you now, sorry.
That's okay, so if you go from actually getting the idea, the door, the story's there,
the
it's already, you've
door
got it from something, you know what I mean?
Yeah,
And shit, and then having it as a, does it change because it becomes food or because it becomes wine or it becomes something else? Or are you
as
still?
long as it's not a copyright infringement, which just the title of the probably is not. They're not using it as a trademark in relation to butcher shop services. So for the trademark aspect, it's fine. Like you could call your publishing company Three Books,
Mm.
and that wouldn't conflict with the butcher shop or Three Books. Because they're different services. Yeah, no, it's good. Sorry, it took me a while to catch on.
Well, explain. Give me explain.
Yeah. Back to Superior Cleaning Care. And further, yeah, so you might be able to demonstrate that there's like consumers are going to be confused. You still need to have this reputation in Superior Cleaning Care. But what if you're a small startup, or you've only been in business for a few years? You might have a few key clients who recognise your name, but you don't have the significant reputation of the general public that supports a passing off claim or a breach of the Australian consumer law. However, if in addition to your company name you've registered a trademark for Superior Cleaning Care, then you could be confident of being successful in a trademark infringement action. This is they're quite clearly substantially identical to each other, and you wouldn't expect the other business, if they're getting proper legal advice, to even attempt to argue against that. But if you're up against an argument for reputation, maybe they would give it a go. But it's just really important, I think, because the clearer you can make it to the other business that you've got a superior claim, the more likely they'll be to cease using it, or at least to come and negotiate an agreement with you, rather than having an argument about reputation in court. So the cleaning business, that's an actual representative of a real situation with one of my clients I'm dealing with. I've just changed the names around in the business a bit. Fortunately, my client's been trading for 40 years, so hopefully they can demonstrate proper reputation, but if it's not for that, they'd be in a bit more trouble, I think. And even so, we're still having trouble with the other side, because without a registered trademark, they're not really recognising that we've got a claim. And so we're having trouble getting them to stop using it. And all they've done is put "and" in the middle. Registration also puts other people on notice, so that can be a deterrent from them from using your trademark. Potential users of a similar trademark are not going to be able to register their own if yours is on the register, or if they see it on the register, they might be dissuaded from using it because they probably don't want to be confused with you either. And they also could be deterred, they don't want to infringe a trademark. If this isn't because of a moral obligation, they at least might be concerned about potential future claims against them. You'll also be more easily able to sell a registered trademark or license it to others to use than you have when you've got an unregistered one. Registered trademarks are the only ones which can use the little R in a circle symbol to indicate registered trademark. Unregistered trademarks are not legally allowed to use that. They can only use the TM symbol, and that's still a good idea to do that if you do have an unregistered trademark, particularly if you've got something descriptive you've been using for a short time and you want to keep it, then if you can put the TM next to it, that can be helpful to build up your use, and then you might be able to get a registered trademark later. And it puts other people on notice that you're using it as a trademark. It's also easier to prove the aspects of your mark than when you started using it if it's registered, and that can be important for evidence later down the track. So you've got your registered trademark though, and what do you actually do if someone's infringing it? At this point, I'll just flag that the Trademark Office doesn't monitor the marketplace, it doesn't enforce or deal with infringers. It's up to you to do this. Lots of clients will consider they're across their industry and they'll notice something quickly if a competitor with a similar name or trademark comes up. But it's probably better to have some sort of system in place for making regular checks through search, as I mentioned earlier, and then you'll ensure no one's infringing your trademark. But if you're doing these checks or you're in an industry where it's going to be obvious and you come across a similar brand trademark and you think it's substantially identical or deceptively similar to yours and in a closely related industry, the first step is to send a letter of demand. So this can demand the other person to cease using and require undertakings of them to not use it anymore. And we'll at least put you in a position to negotiate or find out more about the other business, whether you might even be comfortable coexisting with them. We start off with a letter of demand and it opens up the communication channels. We can often reach a mutually accepted position, or where there's blatant copying or clearly a similar brand being used, then we can effectively demonstrate the position in the letter and obtain agreement to stop using the trademark. They might have to change a website or take down social media posts, or cancel business names, things like that. If it's not successful or you can't reach a coexistence arrangement, then you would have to consider court actions for preventing the infringing actions. And taking steps to address and enforce your rights against infringers is an important protection in itself. Once you start allowing others, particularly those in the same industry, to use your trademark or something similar, then that can weaken your mark, because it might be seen to become an industry term or so commonly used that it becomes descriptive. Of course, you've got a somewhat descriptive trademark to begin with, it's even a greater risk if you're allowing people in the industry to use it. If you're doing your searches and you find that the potentially similar trademark has appeared on the trademark register in Australia, then you can make an opposition to that application if you're within time. You have 2 months from acceptance to do that. So larger companies like Woolworths and Toyota and Qantas and all, they're monitoring the trademark register all the time. They can jump on these conflicts quite quickly. but smaller businesses can do this too. I've got a client in the food industry and we've made a couple of successful oppositions against similar trademarks for him. His surname's unfortunately similar to food. So a lot come up. In some cases, all it's taken is filing the opposition, because if the other person doesn't lodge the notice of intent to defend, it will lapse. And so that's, they might just think, oh, we can't be bothered defending it, and they don't do it. And then that's been great because my client's got a successful result, and that's unlikely to go into it. In other cases, the opposition can open the door for negotiations, and you can work out some coexistence arrangements, and you can do things like make an agreement to limit the other person's use of the mark. Like, so if you're in the food industry, you can use it for chocolate and I'm going to use it for crackers. That might be a way around it if both parties are comfortable with that. But when you're first on the register, you've got the superior bargaining position. So you normally don't have to concede any laws. You can get the broad use and make the other person have a narrow use. Something important to remember is that a business name is different to a trademark. But having a business name doesn't offer the same protection as a registered trademark, and it certainly is not going to protect the business owner from a claim of infringement of another person's trademark. Business name registration is just a regulatory system. Registration's a requirement, and it's an offence not to register, but it doesn't convey any ownership rights over the name or any rights to stop others from using the name. On the other hand, trademarks have ownership rights, and registration affords protection to the owner by providing a mechanism to enforce those rights, which is through the infringement mechanism of being able to make claims against others using substantially identical or deceptively similar signs in their business. So while the Australian Securities and Investments Commission won't allow identical or nearly identical names on the business names register, you only need minimal changes to overcome this. So sometimes a common change is just to add SA or Adelaide, and that makes the name different enough for business name registration. And such a minor difference like that, especially when it's descriptive, is not going to work at the Trademark Office. So as an example, the Australian Securities and Investment Commission has allowed registration of these quite similar business names, the Go Pizza, GF Pizza and Go Pizza Dodgers. They're real business name registration, so they've all been allowed. So as you can see, having a business name isn't going to prevent others using and registering very similar names to yours as their business name. Whereas the examination process that's undertaken for each trademark application ensures that there's no substantially identical or deceptively similar trademarks to yours that are being allowed on the register. At the same time, just because you have a registered business name, it doesn't mean you're not infringing someone else's trademark. So ASIC doesn't make a comparison against the trademark register at all when it accepts registrations for business names. In the example I gave earlier about the cleaning business, the other business actually has a registered business name, but let's say Superior Cleaning and Care, which is the same as the company name, my client, Superior Cleaning Care. So without going into detail, ASIC considers that the addition of and makes the names not nearly identical to each other. So it's the company name and the business name both sit on ASIC's register. The other business owner, he's only a small business, and he believed once he had the business name, he was protected. But now he's actually facing claims of passing off misrepresentation and misleading deceptive conduct. Our clients applied for a trademark. So once that goes through, he'll also be infringing the trademark, all despite having a registered business name. He's just really small, doesn't understand. Perhaps more obviously, domain name is different to a trademark as well. So a domain name doesn't give you exclusive rights to use the words in the domain name, and nor does having a domain name mean you're not infringing someone's trademark or passing off So there's numerous number of domain extensions now, or the TLDs, top level domains. This is the end of the website. Like there's .com, .net.au, .com.au, there's now just .au, which is our new domain. We're just at dwft.au now. So we don't have the long-winded at dwfoxtucker.com.au email to talk about and explain to people over the phone. Then there's some unique ones, and there's like hundreds of them, but I just put 3 up there: .legal, .accountant, and .business. I think there is .line as well, actually.
Yes, there is.
Yeah, I thought there was. Yeah, should put that.
I was too slow at getting out of the stuff.
Yeah, that's the other problem, isn't it? And it's nearly impossible and certainly cost prohibitive to get everything. You know, lots of companies have 3 or 4 of the common ones as a protection measure, and the large companies have like a huge portfolio of domain names, but I still think they're not covering every single one. However, if you have a registered trademark, this can assist in preventing other businesses using a domain name that's the same or similar to your trademark, where they're governed under the Australian ones anyway. If someone's using an identical or confusingly similar domain name to your registered trademark, then you can lodge a complaint and request the domain name registrar to cancel or suspend or transfer to you, preferably, the competing domain name. So you will need to show not only that it's identical or confusingly similar to your trademark, but also that the person has no rights or legitimate interests in respect of the domain, and that it's been registered and is being used in bad faith. Bad faith can include intentionally creating a likelihood of confusion with your trademark as to the commercial origin, sponsorship, affiliation, or endorsement of the other person's website or products or services on the website.
So if they're just squatting, can you kick them off?
Yeah, that's what it's aimed at. Mostly it's squatting. So innocent people are more difficult to get rid of because you have to show that they've got no legitimate interest in respect of the domain name and that they're using it in bad faith. So there's those hurdles to satisfy, but without a registered trademark, there's just no scope at all to lodge a complaint. A registered trademark, probably this is spend a bit less time on it, but it's probably more important. But a registered trademark will also lay a claim of trademark infringement if a domain name is substantially identical or deceptively similar to the trademark and it's used to entice or direct consumers to sale of goods or services covered by your trademark. So mere registration of a domain name is probably not infringement. It's about how they're using the website. And if they're using it to sell goods or services that are similar to yours, then that could be trademark infringement. Even overseas people, they're directing sales to Australia. You can see that. It's changing a bit with the internet. The courts are, or it's more Australia-wide, I guess. So we used to be a bit more secluded in our states, in Australia even, but now the Australian courts are taking a bit broader view of how many people can be reached and how many people, members of the public, are aware of trademarks because of the internet. So some thoughts on intellectual property structuring. Often it's appropriate to hold your intellectual property in a separate entity from your trading entity. That can divide your risk and ownership. This can offer asset protection for your intellectual property in the event of a claim against the business if the trading entity is one for which claims can be limited, like a company. However, you need to take care with these structures to ensure the trademark continues to be used by its registered owner. As I covered earlier, it's imperative that the trademark owner uses the trademark, because if a trademark's not used, it can be removed under the user or loser provisions of the trademark legislation. So as an example, you might have an IP holding company or trustee of a trust. Either of those entities might work on the left. They might be the registered owner of all of the intellectual property of the business, including trademarks. These assets are then held separately from the trading entity on the right, which might just be a company. And since the trading entity is the one conducting the business, it's the one using the trademarks. And that means the owner on the left is not using the trademarks, and that puts them at risk of losing their registration. So an owner of trademarks can make use of its trademarks as a licensor. It doesn't have to be trading itself under its brand. However, a licensor will need to have financial and quality control provisions in the license, and they have to be exercised and actively enforced. A case where this was highlighted was when the owners of the Wild Turkey bourbon whiskey brand, they, in what appears to be an attempt they want to control all registered marks involving wild and any form of bird in relation to alcohol. So they obtained registration for wild geese. And it's a complicated story, but someone in South Australia was using it and they wanted it, so they made arrangements to get it off of him and license it back.
Said a similar thing too with an artist in Sydney, artists from overseas in America to here, opened up a restaurant.
Huh?
I think we had a very similar thing here, and he was I can't remember his name, but he was a musical artist. I think it was, and they said, yeah, he had to remove it. It cost him an absolute fortune.
Ah.
He had to minutely change it just because it was the artist. It's quite a big story. That was all.
Is that copyright though?
Yeah, it's for sure.
Sounds vague.
Yeah, it's like a restaurant or a cafe or something that he opened up in Sydney. Smart.
Yeah, so Wild Turkey, trying to get everything they can, they've got the wild geese trademark. South Australian person, they license it back. It's a small South Australian winery. But because they just wanted to have the mark, they didn't really do any quality control over how the winery was using it. They were found that they didn't have sufficient control over the use of the trademark, that the use by the South Australian winery wasn't authorised use, and therefore it wasn't attributable use to the Wild Turkey as the owner. And as a result, Wild Turkey lost its wild geese trademark. Another big, not the South Australian guy, he's just left out in the cold. Therefore, if you've got your trademarks held in a separate entity to the trading entity, which is using the trademark, you should put your licenses in place. And also put quality controls in them, but also on them. So it will be a factual inquiry about whether you've got control as a licensor. Even related entities still would recommend putting a license agreement in writing, because it's so important to demonstrate that the owner uses the trademark through its licensing. In structures involving companies, where they're only owned by one or two people, and they're essentially the controlling mind of the company, you should also be aware of potential look-through of personal liability for directors. There's been some recent decisions where the courts have found that directors, who are often the sole shareholders, and they're basically the controlling mind of the company, that they're liable for the company's conduct of trademark infringement and passing off. One such case was In-N-Out Burgers, apparently the very famous American burger chain. It's where all the celebrities eat, and if the celebrities eating an In-N-Out burger, they take a photo, that sort of thing. In Australia, they don't have any physical stores here, but they did have a really well-attended pop-up restaurant in the eastern states. So I guess because we're South Australia, we don't know about it. And they had lineups around the block for their pop-up restaurants. Anyway, back to the trademark issue. The company that was potentially infringing them was called Hashtag Burgers. They had a fast food operation in Australia, and they called it Down and Out Burgers, and they used very similar signage. And their restaurant get up and what they called their burgers, everything was really complicated. So it wasn't too difficult for the judge to find that this conduct amounted to trademark infringement. The reason it went to court, I think, was about whether it was enough use in Australia to have the pop-up stores, but they said that was enough. So once you had the use, the way they were using it was so similar to the trademark that there was trademark infringement, misleading, deceptive conduct, and possible. But the interesting part of this case that I want to draw your attention to in this context of structuring is the joint liability on the part of the directors was found, and they got personal penalties. To finish, I just want to touch on some copyright issues that relate to trademarks. If any of your trademarks is a logo, there's likely to be copyright in the logo's design or drawing. You should ensure that you obtain an assignment of this copyright from the designer or artist. Although most cases, when you engage someone to design your logo, you'll have an implied license to use the logo in your business because that's the purpose of its creation. You're still in a better position if you actually own the copyright, as you'll then be able to make modifications as you wish to your logo, and you'll more easily be able to license it to others. A further benefit of obtaining an assignment of the copyright is that you then have an ability, if there's a trademark infringement, to sue for trademark infringement and copyright infringement as well, because there'll be a reproduction of the logo. However, if you can't negotiate an assignment with the author to get an assignment of the copyright, you at least should obtain an exclusive license and ensure that that license allows you to use the mark as you need to use it, and it's not subject to restrictions that don't suit your business purposes. You should also obtain a consent or waiver of the author's moral rights. Moral rights are when you have to attribute the author whenever the logo is published. And if you get a waiver of that, you won't need to do that every time you use your trademark. Hopefully, I'm stating the obvious now, but don't copy a design or drawing from somewhere and use it as your trademark. Even if it's not being used as a trademark by someone else, that doesn't make it okay. All copying, reproducing, and publishing an artistic or literary work and other works, including photographs and other things you find on the internet. If you copy anything that's not yours without permission, that will be copyright infringement. Even in your general advertising and marketing of your business, you just need to be vigilant about not using the creative content of others. I think it's particularly relevant in social media posts and internet advertising. There just doesn't seem to be the usual care and thoughtfulness there, but always just make sure that you've got permission or it's your own work. Music, quotes, cartoons, blogs, articles, photographs, all examples of materials in which copyright can subsist. And so none of these things can be taken and used without permission of the author. Just citing the source is not enough to make it okay. Even when permission is given, such as like you might be able to use music on your social media account with your social media post, just make sure you understand how you can use it and how far that scope of permission goes. More than likely, you can only use it for that purpose and not anything else.
So if you do something using Creative Commons where it's available to use under license, that's all right, provided that you then say photographed by
Whatever,
Ivanovich or whatever, and yeah.
Yeah, the Creative Commons license will tell you what attribution you need to make. Or sometimes that you don't need to. Depends. There's a lot of different categories of the Creative Commons licenses.
Yeah.
Key takeaways from today that I want you to think about are when you're choosing your trademark, choose a unique and distinguishing trademark. Do your availability searches. Do your availability searches before choosing your brand, and also utilise them later to keep an eye on your competitors. Register your trademarks. This will afford the exclusive rights to use the marks and the ability to make a claim for infringement. It's a far stronger position than attempting to make a claim in relation to an unregistered trademark. Even if you have a business name or a domain name, register your trademarks because they don't protect your mark of themselves. And the last tip is to continually use your trademark. So this might mean having license agreements in place and quality control processes in place with related companies or other companies that are using it. Q,
Thank you.